Seroquel was first approved by the United States Food and Drug Administration in 1997. However, a study completed in 1996 called Study 15 showed that 53 to 65% of patients withdrew from the trial due to psychotic relapse. 45% also showed significant weight gain. By 2008, Seroquel was AstraZeneca's second biggest selling drug with $4.5 billion in sales. In October 2009, whistleblower lawsuits began, as well as 2 federal investigations over AstraZeneca's illegal marketing of Seroquel for use in the treatment of post-traumatic stress disorder. Stephen Scheller is the attorney who represented the AstraZeneca whistleblower, John Wetter, resulting in a $520 million settlement in April 2010, one of the largest in the history of the False Claims Act. Stephen Scheller, welcome to Wakeup Call. Explain for us this case with Seroquel and this huge $520 million settlement.
Well, what happened historically back in the year 2004, one of the detail reps or marketing representatives of Seroquel came to our firm and asked us to look into the fact that he was quite disturbed because the company, AstraZeneca, which makes Seroquel, was marketing this drug for psychiatrists and for doctors generally off-label. And what that means is marketing it for uses which are not approved by the FDA. And what we mean by not approved by the FDA, the drug company had never been able to prove or even that the drug's benefits for the uses they were marketing for exceeded the risks of using it. So the drug, for example, is okay to use for schizophrenia and for certain very, very serious forms of bipolar treatment. And most of the time, when I say bipolar treatment, what I mean is there are different forms of bipolar mania and depression, which are very differentiated. And what happened is they were marketing it for use in the elderly as a chemical restraint or as a sleeping kind of pill. They're marketing it, it appears, from what I can see, for a number of other uses, for depression, for anxiety. In fact, the name Seroquel almost suggests it's a sleep pill. You've got to wonder how they picked that name. And then you
one of those was post-traumatic stress disorder as well.
Yeah, it's never been approved for post-traumatic stress disorder, and I doubt very much whether it ever will be approved for that. I'd be surprised.
So then, who was James Wetter?
James Wetter was the marketing representative for AstraZeneca who brought that problem to our attention and was very upset about it because he felt very uncomfortable being pressured to sell the drug for what were off-label uses. In other words, uses not approved by the FDA.
And so explain the actual finding on his behalf and what that means from the company's point of view, from AstraZeneca's point of view.
Well, what happened historically is it took a number of years for it to reach the point where we finally resolved the case. But what happened is that the United States Attorney here in the Eastern District conducts an investigation, and we participate and help in the investigation. The case is assigned to a federal judge, and it's kept under seal, meaning there's no disclosure of the investigation during the time it's going forward. And usually the company doesn't have any inkling of who the whistleblower is because the government protects the whistleblower. And what happens is the investigation begins usually with an evaluation of the material that the whistleblower, in this case Mr. Wetter, gives the government. The government then will conduct investigations using investigators, including possibly the FBI, including a whole slew of possible investigators, the Food and Drug Administration investigators, and they collect information. They often subpoena data from the company, marketing materials. Those materials could be subpoenaed from their ad agencies, and then begin to evaluate them. The company still doesn't know who the whistleblower is because that information has been kept secret until there is a final settlement and the whistleblower is willing to come forward. And that's what happened in this case. And it wasn't until very recently, as you know, that the company agreed to pay the $520 million, which basically is the money the company had no business earning from Medicare and Medicaid. It isn't the total amount of off-label marketing. There's still private insurance companies. There's lots of people who get Seroquel who there has been no income recovery for. In this case, for example, the Veterans Administration would be entitled to a recovery for drugs that they paid for. And this is an extremely expensive drug, which is then the money gets returned to the Treasury.
So then the VA, the Veteran Affairs Department, could get money would be paid to them on the basis that they were applying the drug to veterans for the treatment of PTSD, which has now been established as not being applicable for the treatment of PTSD when it comes to Seroquel.
No, it is not applicable and should never be used for that. In fact, it's my view, and of course I'm not a doctor, but I certainly know quite a bit about it now, that this is a drug that is a numbing drug. So it's certainly not the kind of thing that you want to treat post-traumatic stress disorder in most instances. The proper treatment, as I understand it, for post-traumatic stress disorder is cognitive behavioral therapy and certain eye movement orientation, desensitization, so that the veterans can participate in reprocessing. And it's not just talk therapy, it's very specific therapy, and it's a long-term therapy. And the pill is like a quick fix. In fact, it's very disturbing that the pill is being used, but I am suspicious that Seroquel is addictive because we know that it's used in our prison systems because that was also involved in our case to some degree.
How is it used in the prison system?
Yeah, the prisoners love it.
But how is it used?
Same way. Prisoner comes in, says, I'm depressed or something, and they pitch him some pills. And they, as I say, they're very expensive.
And so, staying with the legality of this case, why was the amount so high, $520 million? Is that a really high amount, or is that a drop in the ocean?
That is the highest, I think it's the highest single drug settlement in the history of the False Claims Act. I was also involved that was a civil settlement. I was also lead counsel for the settlement on Zyprexa, involving Eli Lilly, and that was a settlement of $1.4 billion, but a good chunk of that was a criminal penalty. This case did not have criminal penalties. It had civil penalties, civil payment only.
So would that mean then that the VA, for all those soldiers, all those veterans who had been diagnosed and prescribed Seroquel, what could they ultimately do as a result of this legal ruling? Well,
they can't use the finding in court, but this is information that they should be aware of, that the drug is being used off-label, and it is not approved for post-traumatic stress disorder treatment, and has a very, very serious adverse event profile. Tardive dyskinesia, which is a very serious permanent effect, and suicide. It increases the risk of suicides. It increases the risk of diabetes because it causes substantial weight gain. It has a whole plethora of effects, and the longer you take it, the more dangerous it is in terms of adverse events. And most of the trials which you read about in the label are very short term. They're 6 weeks, they're 8 weeks. And what should happen here is that the drug should be prohibited for use in veterans if it's being used for post-traumatic stress disorder without complying with a requirement that they prove it has long-term effectiveness for that to the FDA. And so far as I know, they haven't done it.
And closing question then. So when it comes to the law, Seroquel, veterans and post-traumatic stress disorder, given this ruling, what does this mean for those families who questioned whether their children should even have been given a drug like Seroquel in the first place? What does the law say about that?
The real question is, why are the doctors, the psychiatrists, prescribing it? And also, it raises serious questions about the question of whether you can sue the psychiatrist or whether you should sue the psychiatrist and the various immunities given to them in medical malpractice cases. Because they are allowed to prescribe the drug. You have to understand, it is not illegal for a psychiatrist to prescribe a drug off-label, as we call it. They're allowed to do that. And that's how these cocktails get going. You might as well go to the local bar and get a better mixture there. It's probably safer.
Stephen Scheller, the attorney in the whistleblower case that led to one of the largest claims in the False Claims Act history.